Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us, coming to you yet again from Washington's premier indoor shooting facility. Of course, that's Security Gun Club right here in Woodinville, Washington. Hey, we need to talk about a case that has a lot to do with unserialized, untraceable firearms, or what people on the other side sometimes call ghost guns. It's a very, very important case, not only for the state that it comes from, Oregon, very important case for you, but I think all of us on a national level probably ought to pay attention, because if you want to see a case that could come to fruition quite rapidly, and therefore a case that could rapidly accelerate itself through the appellate system and get some resolution on the matter, it probably is this case, because Oregon, they got it teed up pretty good. So today, let's go through the pleadings, let's geek out for a little bit, let's get you educated, and let's talk about why everyone needs to pay attention to this case, especially Oregon. Okay, before we get going too far down the road we're going down, proud to announce that this video is being brought to you by Right to Bear. That's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have Right to Bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com. Okay, the case that we're talking about today is the case of Montgomery versus Rosenblum. It is a case that is filed in the United States District Court for the District of Oregon in the Portland Division. It is a case brought to us by our good friends at the Firearms Policy Coalition, as well as the Oregon Firearms Federation, which means, of course, we will have links down below for both of them for you to show them some love. This is a challenge to Oregon House Bill 2005. House Bill 2005 banned large swaths of previously legal items, including any untraceable firearms, so that is going to have to deal with the components and the materials used therein and whether or not it can be detected by metal detectors or x-rays, and all untraceable, unserialized firearms, as well as the importation or sale of any unserialized receivers, or what we sometimes call 80% lowers. Now, Oregon, this is the big deal, and you need to understand this. This law is set to go into effect September 1st of this year, which is less than a month away, okay? And if you take a look at this law, and unless this lawsuit gets this law enjoined, come September 1st, the only way, Oregon, that you will remain compliant with this law and not subject yourself to criminal prosecution is if you have serialized any of your unserialized firearms. And then what it takes to get that done is a whole nother video that we will do later on for you in Oregon if you guys have interest in that, so that for those of you who actually want to comply with this law or worry that this lawsuit doesn't get you anywhere. But the date is September 1st. Okay, and so the time to start thinking about it is right now. Now, in a nutshell, this is what the plaintiffs are challenging here. In 2023, Oregon enacted House Bill 2005, which, among other things, bans 1, the manufacture, importation, sale, transfer, or possession of so-called undetectable firearms, 2, the sale, transfer, or possession of unserialized firearms, and 3, the importation, sale, transfer, or possession of an unserialized, unfinished frame or receiver. The net effect of HB 2005 is to criminalize the core aspects of self-manufacture of firearms. Oregon bans are scheduled to take effect on September 1st, 2024. Circle that date on your calendar, Oregon. The plaintiffs also state the bans are unconstitutional and cannot stand. When, as here, the Second Amendment's plain text covers an individual's conduct, manufacturing arms, possessing the materials necessary to do so, and ultimately keeping and bearing such self-manufactured arms, the Constitution presumptively protects that conduct. To justify its regulation, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearms regulation. Okay, there we have it. It's the Bruin test. Number one, does the plain text of the Second Amendment cover the conduct? Well, let's see. This is about acquiring, possessing, and keeping arms. So yes, in fact, it does. So then it becomes Oregon's responsibility, their burden of proof, if you would, to prove that there is some historical analogs, relevantly similar historical analogs, which would justify this sort of restriction. But here's the problem for Oregon, and this is going to be the problem in any state where we're trying to determine the constitutionality of these sorts of bans, which is when you go back and look at history, not only do they contradict the bans, in many ways they absolutely promote the position of the plaintiffs here. Throughout American history, people have been free to personally manufacture, construct, and/or assemble arms for lawful purposes, including self-defense in the home. In defiance of this historical tradition, Oregon's ban completely and categorically prohibit individuals not prohibited from exercising their Second Amendment protected rights from possessing, acquiring, and self-manufacturing firearms that are of types, functions, and designs and are themselves commonly owned and possessed firearms, self-made firearms that do not bear a manufacturer's serial number, as well as the component parts used to build such arms by a law-abiding citizens for lawful purposes. Word to the plaintiff there, hey, a punctuation here and there and not a huge run-on sentence like that would probably be a little bit better grammar, but the points they make is exactly correct here. You go back and you take a look at our historical analogs. No, people were all assembling their own firearms, and they weren't serializing anything, and any of the materials or tools needed necessary to do that, well, those were all readily available. There was not one iota of restrictions on any of that activity. Put simply, HB 2005 makes it a crime to sell, transfer, or possess an unfinished frame or receiver that lacks a serial number. And that ultimately is what it comes down to. If you have an undetectable firearm without a serial number, if you have an unserialized firearm, which clearly would not have a serial number, if you have any type of lower receiver that has either been assembled into a fully functional firearm or just standing alone, that all becomes unlawful September 1st of 2024. And the only way that you can remain compliant with the law is to serialize these components. But you see, the problem is if you don't want to comply, well, then you are having property taken from you. And of course, if you don't want to comply with a law that you believe is unconstitutional, now we're getting into the areas of unconstitutional takings and such. For example, the plaintiffs point out, as described above, each of the individual plaintiffs lawfully own arms or non-firearm objects that fall within Oregon's bans. As a result, plaintiffs must dispossess themselves of, render permanently inoperable, or, where applicable, serialize their property before September 1st, 2024, or risk criminal sanctions. Plaintiffs will also be harmed by defendants' enforcement of the bans, which will extinguish any legal market for the regulated items. Now, you know where the state of Oregon is going to come from here. They're going to make one argument, which is, hey, listen, we're not banning their ability to possess firearms. We're just telling them what kind of firearms they can possess. And then all the other non-firearm objects that we're banning, yeah, well, the Second Amendment doesn't even cover them. They're not arms to begin with, and we have the right to regulate that as industry. Of course, the plaintiffs point out, these principles confirm that plaintiffs' proposed course of conduct to manufacture arms, possess the materials necessary to do so, and to keep and bear self-manufactured arms is covered by the Second Amendment's text. The right to self-manufacture wouldn't mean much without the right to own, possess, and use the items and materials necessary to engage in such activity. And, of course, the firearms ultimately produced, so long as such firearms are themselves protected by the Second Amendment and not subject to prohibition. And so, yeah, you can't just manufacture at home a machine gun and then not comply with the NFA. So the plaintiffs here are not going to the extreme levels. What they're saying here, though, is that if we're going to take a look at the core activity, the ability to manufacture your own firearms and to do so without serialization, yeah, that is a rich, rich historical tradition of allowing Americans to do exactly that. And then, of course, what they want to manufacture are not muskets or some other types of crazy or antiquated firearms. They want to manufacture firearms which would be used today for self-defense, or as we like to call, in common use. And the plaintiffs play on it this way. Apart from the right to self-manufacture, the bans also unconstitutionally infringe on the right of ordinary Oregonians to possess constitutionally protected arms. It is clear that the Second Amendment protects the possession and use of weapons that are in common use at the time. And so even though Oregon is going to have to justify these laws through historical analogs, and this is where, of course, I get really, really worried about how Rahimi's going to get shoved down our throat, because this is going to be a more modern problem requiring a more nuanced approach, which is going to allow for something relevantly similar to justify it. But as the plaintiffs wisely point out ahead of time, throughout American history, people have been free to personally manufacture, construct, and/or assemble arms for lawful purposes, including self-defense in the home. Manufacturing of firearms was not just common, but was entirely unregulated during our colonial and founding eras, and there were no restrictions on who could be a gunsmith or manufacture arms. And of course, in anticipation that Rahimi will be cited, and it will be, by the state of Oregon over and over and over, the plaintiffs use a little preemption here and point out, to the contrary, the principles that underpin the nation's regulatory tradition, citing to that, establish that individuals must remain free to self-manufacture firearms for lawful purposes. In short, the Second Amendment's text, as informed by history, firmly establishes the right to self-manufacture firearms and to possess and use the items and materials necessary to construct such arms for lawful purposes. Okay, remedies. What are the remedies? Well, they are challenging this law under both the Second and 14th Amendment. They are saying it violates your civil rights under 42 United States Code Section 1983. They are asking for an immediate temporary injunction. That's the thing you need to focus on right now, Oregon. Are you going to get a temporary injunction on this law before September 1st? If not, this law goes live, and many of you, unless you've complied with it, will be outside the confines of the law. So there's going to be a motion for a temporary injunction. Whether that's granted or not, there will be arguments on the merit. If, in fact, the plaintiffs were successful, you would see a permanent injunction issued. This is going to be a case that's going to rapidly move through the system, especially with the implementation date coming up in less than a month. The case, once again, is Montgomery v. Rosenblum. We're going to link it up down below so you can geek out on the complaint for yourself. Again, kudos to the Firearms Policy Coalition as well as the Oregon Firearms Federation for bringing this suit. You may have more questions about this issue or something else related to what's left of our Second Amendment rights. If you guys do, you should know how to get a hold of Washington Gun Law by now, but if you don't, that's okay. That information is down there in the description box. Maybe you got an idea for a video. If you do, go ahead and click on that link right there. Let us know. Or maybe you just want to be part of our monthly newsletter. Hey, the information on how to subscribe to that is down below in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.